Exam Scholar, Real Estate Edition.
Question 1. Which of these instruments does not contain the interest rate, loan amount, term of the loan, and monthly payments? A. Mortgage. B. Deed. C. Lease. D. None of these? Answer. D. None of the listed instruments contain the interest rate, loan amount, term of the loan, or monthly payments. The type of instrument that does contain these is the note. Question 2. Anthony receives a tax bill that is related to cost per front foot and amount of benefit he receives. This type of tax bill would be called A. Eagle. B. Special assessment. C. Front foot assessment. D. None of these. Answer. B. Special assessments are generally repayment to the government for installation of curbs, gutters, and other enhancements. The cost of these is based on the amount of benefit that a particular property receives from the enhancements. Question 3. Retaining a property while at the same time using it as collateral to secure a loan is called A. Promissory. B. Hypothecation. C. Accretion. D. Collation. Answer. B. The act of using property to secure a loan while at the same time retaining the use and benefit of the property is called hypothecation. Question 4. In which clause does it allow for a buyer to be free of recourse in the event of foreclosure? A. Ad hominem clause. B. Dispersal clause. C. Exculpatory clause. D. Extradition clause. Answer. C. An exculpatory clause acts as a non-recourse loan. This means the lender can only look to the property for the satisfaction of the loan. The buyer is not personally responsible for the note. Question 5. Referral fees are legal to be paid if they are given to A. Licensed brokers. B. Licensed agents. C. Anyone. D. None of these. Answer. A. Referral fees are legal to be paid only to licensed brokers. Question 6. The secondary mortgage market consists of which major participants? A. Fannie Mae. B. Ginnie Mae. C. FHLMC. D. All of these. Answer. D. Fannie Mae, Ginnie Mae, and FHLMC are all major participants in the secondary mortgage market. Question 7. What does a general warranty deed contain? A. Covenants that warrant the new owner's undisturbed and clear title. B. Covenants that include provisions of a quitclaim deed. C. Covenants regarding quiet enjoyment. D. None of these. Answer. A. Covenants that warrant the new owner's undisturbed and clear title are contained in a general warranty deed. Question 8. A general agent has full authority to A. Bind the principal to all agreements. B. Act as attorney at law. C. Act in the bounds of power of attorney. D. Only bind principal to agreements with written consent from the principal. Answer. A. A general agent is a representative of a principal that has the full authority to bind the principal to all agreements. Question 9. The income approach to appraisal uses which kind of rate? A. Market. B. Capitalization. C. Index. D. Consumer. Answer. B. The capitalization rate, or cap rate, is used in the income approach to appraisal and is an analysis of how much investors are willing to spend in a certain neighborhood in return for a certain amount of income. Question 10. Which of these is an example of a general agent that has the authority to make binding decisions on behalf of the principal? A. An attorney at law. B. A real estate agent. C. A real estate broker. D. A property manager. Answer. D. A property manager is a good example of a general agent who has been empowered to make binding decisions on behalf of the principal. Question 1. At the close of the Civil War, a law that extended equal rights and real property to members of all races is called A. The Civil Property Amendment of 1866. B. The Property Rights Clause of 1868. C. The Civil Property Rights Act of 1865. D. The Civil Rights Act of 1866. Answer. D. The Civil Rights Act of 1866 is the law that granted equal rights and real property to all races in the United States. Question 2. The Civil Rights Act of 1866 prohibits discrimination in real estate based on A. Nationality and religious beliefs. B. Religious beliefs. C. Gender. D. Race. Answer. D. The Civil Rights Act of 1866 prohibits discrimination in real estate based on race. Question 3. A person with a child under the age of 18 is protected by the federal ban on discrimination based on familial status in order to A. Provide equal access to rentals. B. Allow for blockbusting to occur. C. Provide equal rights to families. D. Allow for a family to live in a tract neighborhood. Answer. A. The federal government provides protection from discrimination for people who have children that need places to live. This protects people from landlords that may try to not allow a person to rent or lease that has children. Question 4. An easement is defined as A. The legal right to pass over your neighbor's land. B. The right of way through your own property. C. The gradual easing away of land by water. D. None of these. Answer. A. An easement is the legal right to pass over another's land to get to your own or another's land. Question 5. The holder of a life estate may A. Maintain the property. B. Direct the disposition of the property at the end of the life estate. C. Renew agreements of the life estate in full. D. None of these. Answer. A. The holder of a life estate may maintain the property for the duration of the life estate. Usually the duration of a life estate is based on the life of an individual. Question 6. If Charles finds a home that is for sale by the owner and tells the owner that he will pay the full asking price and promises to send an earnest money check in the mail in the next 5 days, this contract is A. Valid. B. Void. C. Voidable. D. Unenforceable. Answer. D. According to the Statute of Frauds, all contracts for the sale of real estate must be in writing to be enforceable. Question 7. The value of an investment property, as estimated by an appraiser, the potential gross income does not include A. Settlements from the state government for losses due to eminent domain. B. Estimated rental income based on full occupancy. C. Fees related to parking and storage areas. D. None of these. Answer. A. Settlements or proceeds from the sale of land is not considered in the appraiser's valuation. Question 8. If Janice owns and occupies one side of a two-family house, and she wants to advertise the other side of the house as a non-smoking rental, Can this be legally done without discriminating? A. Yes. The right to smoke is not protected by law. B. No. She cannot advertise discriminatory practices in regards to real estate. C. Yes. Since she is occupying part of the house herself, law provides for this protection. D. No. The only type of discrimination she can use is based on race. Answer. A. There is no law that protects a person's right to smoke. Advertising a rental as non-smoking is not discriminatory and is therefore legal. Question 9. When there is a conflict in limitations on the development of property, which rule applies? A. The least restrictive. B. The most restrictive. C. There is no rule to determine this. D. None of these. Answer. B. The most restrictive rule applies when there is a conflict in limitations on the development of property. This comes into play if there are zoning restrictions that conflict with architectural restrictions or deed restrictions. Question 10. If an appraiser was using the Consumer Price Index method to determine reproduction costs, this would be A. Reliable. B. Not reliable. C. Acceptable. D. Void. Answer. B. Reliable methods of determining reproduction costs are the square foot method, most common, cubic foot method, unit in place method, and quantity survey method. Question 1. What special type of ownership is available in most non-community property states and is only available to married persons? A. Estate by escheat. B. Tenancy by the entirety. C. Dual tenancy. D. Coup estate. Answer. B. Tenancy by the entirety is available in most non-community property states and is automatically the assumed form of ownership when a couple purchases real estate together unless they opt for another form. Question 2. If a restaurant is located in a section of town that has been rezoned from restaurant and retail to commercial office building development, the restaurant can remain there by use of A. A special use permit. B. Non-conforming use. C. The grandfather use clause. D. Tenancy in specuity. Answer. B. The restaurant can remain in place by non-conforming use. The restaurant will not be able to expand into other neighboring sites, however. Question 3. A broker gives a written step-by-step instruction manual to new agents and instructs them to follow each of the steps exactly in order to produce sales for the brokerage. In addition, the broker threatens to discipline any agent that does not follow the steps, up to and including termination. The agent should A. Be scared of losing the position in the brokerage by means of firing. B. Follow the directions step by step. C. Do what they feel is best for obtaining results for the brokerage. An agent is an independent contractor and liable for results only, not the means they are achieved. D. None of these. Answer. C. A real estate agent working under a broker is liable to the company only for the results achieved as defined in the hiring contract and not by the specific means they are achieved. This is an independent contractor arrangement. If it were an employer-employee relationship, the employer can dictate the specific means of obtaining performance. Question 4. To match the specifications of a subject property, in the market data approach to appraisal, the sales prices of comparable properties are A. Increased. B. Decreased. C. Adjusted. D. Net zeroed. Answer. C. In the sales or market data approach to appraisal, the sales prices of comparable properties are adjusted to match the specifications of a subject property. Question 5. In real estate, the simplest form of property ownership is called A. Joint. B. Tenancy in common. C. Community. D. Severalty. Answer: D. The simplest form of ownership in regard to real estate is severalty because there is only one owner. All other forms include multiple party owners involved. Question 6. What is the formula for determining the value of an investment property? A. Net operating income divided by capitalization rate. B. Capitalization rate multiplied by net operating income. C. Potential gross income divided by operating income. D. Potential gross income divided by capitalization rate. Answer: A. Net operating income is divided by the capitalization rate to arrive at the value of the property. Question 7. If a buyer decides to pay for a property in cash, which form is required to be filed according to the IRS? A. Form 1090. B. Form 9600. C. Form 8300. D. Form 2740B. Answer: C. IRS Form 8300 must be filed on all cash payments that are $10,000 or more. Question 8. A cash payment of $10,001 is given as earnest money to secure a property. What must be filed? A. A documenting receipt. B. A procurement contract. C. An IRS Form 8300. D. An expediting loan form. Answer: C. The IRS requires any cash payments over $10,000 be recorded by filing a Form 8300. Question 9. A vendor vendee is a term that best describes the relationship between A. Purchase and sales. B. Mortgage or mortgagee. C. Grantor grantee. D. Option or optionee. Answer: A. The term vendor vendee is best matched with purchase and sales. Question 10. Which term is best related to lender borrower? A. Grantor grantee. B. Mortgage or mortgagee. C. Option or optionee. D. Seller buyer. Answer: B. The best match from this list that is related to lender borrower is mortgage or mortgagee. This relationship is a lender borrower relationship. Question 1. Restrictive covenants included in deeds for all properties within a subdivision can dictate: A. The architectural style of the structures. B. The ethnicity of prospective owners. C. The gender of future tenants. D. None of the above. Answer: A. Restrictive covenants cannot violate any existing laws, and are therefore illegal if they do. The ethnicity and gender of any prospective occupant is protected under federal law. A restrictive covenant can dictate the architectural style. Question 2. If Mary really wants to purchase John's house, and tells John's agent that she is willing to pay $560,000 for it instead of the list price of $540,000, John's agent should A. Tell John because Mary told him not to offer that amount unless it is needed. B. Tell Mary that she will need to submit the proper paperwork for such an offer. C. Tell John. As John's agent, there is a duty of notice due to John and no confidentiality due to Mary. D. Take the listing off of the MLS. Answer: C. Even though Mary deserves honest and fair treatment, there is no duty entitled to Mary by John's agent. John's agent is bound by a duty of notice to John. Question 3. If a person dies that owns this type of estate, the ownership of that person automatically terminates. A. An estate in reversion. B. An accretion estate. C. A life estate. D. A lease pendens estate. Answer. C. Upon the death of a life tenant, the ownership in the life estate terminates. In addition, a life estate may be based on the lifespan of a third party. Question 4. In which of these circumstances is title to real property conveyed voluntarily? A. Eminent domain. B. Tax deed. C. A will. D. A certificate of title. Answer. C. A will is the only choice here that conveys title to real property voluntarily. The other choices, tax deed, certificate of title, and eminent domain convey titles to real property involuntarily. Question 5. A tenant looking to lease a property during a period of high inflation would most likely want to have a lease based on A. The cost of living index. B. The consumer price index. C. A tiered payment structure. D. A fixed rate. Answer. D. The tenant would most benefit from a lease that was based on a fixed rate during inflationary times. If the property manager based it on any of the other answers, the property manager could raise the rent as the market dictates. Question 6. As a buyer in a cooperative apartment, you will not receive A. A lease. B. Shares in the organization. C. A deed. D. None of these. Answer. C. A co-op apartment is personal property, not real property or real estate, and therefore no deed is given. Question 7. In order to have a legal and valid agency relationship, which of these is required? A. A valid real estate license. B. A passing of consideration. C. The passage of at least 48 hours. D. Mutual consent. Answer. D. Mutual consent is the only necessary option of the choices given to establish agency. The other choices are not part of the agency establishment. Question 8. A real estate agent should disclose any environmental hazards or conditions that could have an effect on the property except in which case? A. When there is no need to disclose a hazard because the prospective buyers are from the area and already know what happens there. B. When there is a posted notice on the property. C. When another agent has already spoken to them about the environmental hazards of the property. D. None of the above. Answer, D. An agent has a liability to disclose any environmental conditions that could affect the property or the buyer's intended use. The safest bet is to always disclose, even if you think that you can get away with not doing so. Question 9. A contract for deed is best described as when A. Property purchased on an installment plan. B. A written contract for a future purchase transfer. C. An oral agreement in which the owner sells the property to a tenant for a negotiated installment price. D. None of these. Answer. A. The best answer is property purchased on an installment plan. However, this also would include the seller holding title to the property for at least 1 year after the date of sale. Question 10. In a loan closing, without the proper signature on the note, this is not created. A. Indebtedness. B. A deed. C. A contract. D. An estate. Answer. A. The signature on the note must be proper and valid to create the debt between the borrower and the lender. Question 1. If the expiration of time has passed in regards to the communication of acceptance by the seller from the buyer, this offer is considered A. Terminated. B. Valid. C. No longer an offer. D. None of these. Answer A. One way to terminate an offer from a buyer by a seller is to let the time expire on terms of acceptance. Question 2. In real estate, the offer to perform on the terms agreed is called A. Tender. B. Performance. C. Negotiated. D. Acceptance. Answer A. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called the tender. This typically takes place at the end of the transaction. Question 3. If one party cannot perform their part of the agreed terms of a contract, the victim party can claim the other party. A. Performed negligently. B. Defaulted. C. Is voiding the contract. D. Is causing interference. Answer B. If a party cannot perform their part of the agreed terms of a contract, the other party can claim the other party defaulted. Question 4. If a party was discriminated against, they could A. Bring private action through a state or federal court. B. Bring criminal action through a state court. C. Bring criminal action through a federal court. D. Bring civil action through a state court. Answer A. Because discrimination is not considered a criminal act, the option of the party would be to bring private action through a state or federal court. Question 5. If a buyer of a property wishes to move into the newly purchased home before the close of escrow, the agent/broker should A. Allow it. B. Deny it. C. Obtain written consent from the owner. D. None of these. Answer C. Because the home has not closed escrow, it is still owned by the current owner and therefore the agent/broker must obtain written consent to allow the new buyer to move in before the close of escrow. Question 6. A legal cause of action in which a binding agreement or bargain for exchange is not honored by one or more of the parties to the contract by non-performance or interference with the other party's performance is known as A. Breach. B. Non-disclosure. C. Voidable. D. None of these. Answer A. Breach of contract is when one party does not honor the agreed upon terms of a contract by non-performance or interference with the other party's performance. Question 7. A clause that states a lender may demand the loan amount plus accrued interest in the event of a sale is called A. Addendum. B. Non-performance. C. Acceleration. D. Alienation. Answer D. The clause in which a lender may call in the loan plus accrued interest in the event of a sale is known as alienation. This is different than an acceleration clause in which the loan can be called in due to non-performance of contractual duties, such as not paying mortgage payments. Question 8. What type of arrangement is a less than freehold estate? A. Owner/tenant. B. Tenant/sublessee. C. Lessor/sublessor. D. None of these. Answer A. A less than freehold estate is an owner/tenant arrangement. Question 9. If an as-is clause is inserted into the sales contract for a property that seems to be generally okay on the outside and inside, this would be A. Allowed. B. Disallowed. C. Allowed only in cases of obvious defects. D. None of these. Answer: C. The only way an as-is clause is allowed in most situations is if there are obvious defects that any prudent person could discover. Typically, they are disallowed by the real estate commissioner to protect consumers. Question 10. If one is transferring or conveying title to real property, it is called A. Alienation. B. Alluvion. C. Accretion. D. Succession. Answer: A. The term alienate in real estate means to convey or transfer.
Exam Scholar, Real Estate Edition.